Hey everyone, welcome back to @SIP GDPR Guide, your privacy law pit stop. In today's video, we're cracking open one of the most critical parts of the GDPR. Article 6, Lawfulness of Processing, might sound a bit dry, but trust me, understanding when and how you can legally process personal data is not just crucial for compliance, it's about building trust with your audience. So, grab a coffee, because we're about to demystify it all. Have you ever wondered when you're legally allowed to collect someone's data? Not whenever you want. Let's make this simple, visual, and most importantly, practical. So, what exactly does lawful processing mean under GDPR? Think of it like this: personal data isn't just floating around for anyone to use. The GDPR insists that for any processing of personal data to be legitimate, it must have a lawful basis. It's like needing a valid reason or a ticket to enter a secure area. It's not just about asking for consent. While consent is super important, there are actually several other valid reasons laid out in Article 6. We're talking about legality, permission, and fairness at its core. Get these bases right, and you're well on your way to GDPR compliance. Alright, let's reveal the magnificent 6. Article 6 provides 6 distinct legal grounds, your tickets, for processing personal data. You only need one of these to justify your processing. Think of them as 6 different doors you can walk through, but you need to pick the right one for your specific situation. Let's break each one down with examples you can actually relate to. First up, and probably the most well-known, consent. This is when the individual, often called the data subject, freely gives their specific, informed, and unambiguous permission for their data to be processed for a particular purpose. Example: imagine you're signing up for a newsletter. That little checkbox that says, "Yes, I'd like to receive marketing emails about amazing new products." That's explicit consent. It has to be a clear, affirmative action. No pre-ticked boxes, no vague language. And here's the crucial part: they must be able to withdraw that consent just as easily as they gave it. Think about the unsubscribe link at the bottom of every legitimate email. That's consent in action. Next, we have contract. This basis applies when processing is necessary for the performance of a contract with the data subject, or to take steps at their request before entering into a contract. Example: let's say you buy a new laptop online. The retailer needs to process your name, address, and payment details to fulfill that order and deliver the laptop to you. That processing is necessary to perform your contract with them. They're not doing it just for fun, they're doing it to deliver what you paid for. Similarly, if you apply for a job, processing your CV is necessary to take steps before a potential employment contract. Our third basis is legal obligation. This one's pretty straightforward: you're processing data because you have to by law. It's not a choice, it's a requirement imposed by legislation. For example, a company must keep records of employee salaries and taxes to comply with tax laws. They don't need your consent to do this, the law mandates it. Or, if a court orders a company to disclose specific data during a legal dispute, processing that data for disclosure falls under legal obligation. It's about meeting regulatory duties. Fourth, we have vital interests. This is the one you hope you never have to use, because it's about protecting someone's life. Processing is necessary to protect the vital interests of the data subject or of another natural person. Imagine a hospital receiving an unconscious patient. They might need to quickly access medical records to understand allergies or critical health conditions that could save their life, even if they can't get immediate consent. This is about preventing serious harm or death. It's a very high threshold and rarely used outside of emergencies. Number 5 is public task. This applies when processing is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. This usually applies to public authorities, government bodies, or organizations performing functions in the public interest. Suppose a local council processing your address to send you a voter registration form. Or a public health body tracking the spread of an infectious disease. They're acting on behalf of the public good, under specific legal powers, and their actions are typically laid out in law. Finally, we have the often debated, but highly useful, legitimate interests. This is where processing is necessary for the purposes of the legitimate interests pursued by the controller or by a third party, unless those interests are overridden by the fundamental rights and freedoms of the data subject. This is often used for things like fraud prevention, network security, or even direct marketing if it's done in a way that respects the individual's rights. For instance, an online store analyzing your browse history to recommend products you might genuinely like, as long as it doesn't overly intrude on your privacy and you have a clear way to object. The key here is a balancing test. Your legitimate interest must genuinely outweigh any potential negative impact on the individual's rights and freedoms. This is why transparency is so important with legitimate interests. Here's a hypothetical look at how organizations might rely on these different bases. As you can see, consent and contract often feature highly, especially in consumer-facing businesses. Legitimate interests is also widely used, but remember that balancing act. Understanding this helps you see where others are focusing their compliance efforts. Let's quickly recap the absolute must-knows about Article 6. 1. Choose a lawful basis before you process data. Don't just collect and then figure it out later. Be transparent. Tell individuals what basis you're using. Some bases have specific requirements. Consent needs to be easily withdrawable, legitimate interests needs that balancing test. Document everything. This is your proof of compliance. And finally, if your purpose for using the data changes, you might need to reevaluate and find a new lawful basis. It's not a set it and forget it situation. Let's talk about special considerations under Article 6, especially when it comes to processing data based on legal obligations or public interest tasks. Under Article 6, 2. When an organization processes data under Point C, legal obligation, or Point E, public task, the GDPR says the basis must be clearly defined in EU or national law. Let's say a city government collects data to issue driving licenses. That's a task in the public interest. Or an employer collects your tax information, that's due to a legal obligation. In both cases, the GDPR says the law itself must tell us why the data is needed, what type of data is involved, who it's shared with, and how long it's stored. Under Article 6, 3. Member states have flexibility. They can introduce or keep their own laws to define storage periods, clarify who gets access, or lay down rules for special data types, like health or education data. But, those laws must always meet a genuine public interest and be proportionate to the goal. Under Article 6, 4, says, if an organization wants to use personal data for a new purpose that's not covered by the original reason, or the person didn't give consent. In that case, GDPR says, you have to check if the new use is compatible with the original one. Here's how. Is the new purpose closely related to the original? Did the user expect it? Is the data sensitive? Like health or ethnicity? Could this harm the data subject? Have you used safeguards like encryption or pseudonymization? If the answers make sense, you may proceed. If not, you need consent or a new legal basis. To sum it up, public bodies can't rely on legitimate interest. If you're using legal obligation or public task, the law must clearly spell it out. Member states can add specific rules, but they must serve the public and respect privacy. Want to reuse the data? Better check it's compatible. Thanks for watching, and I'll see you in the next video. Hit that like button, share with your team, and subscribe to @SIP GDPR Guide for more content like this.